A while ago, I did a video where I walked you through the day in the life of a litigation attorney. I showed you what was involved in preparing for a short trial that I had coming up. I may be doing YouTube videos on a daily basis, but I am also still doing law. And today I'm going to show you the other side of law, not the litigation side, but the corporate commercial. Consequently, today I shall be reviewing a commercial lease for a client, and I will walk you through my thought process and reflections as I do so. Two important caveats. Nothing in this video constitutes legal advice. It is not fact specific, it is not jurisdiction specific. These are just overall principles that I like to keep in mind and sensitize my clients to before they sign a lease. Second thing, I am not wearing sunglasses to be cool. These are prescription sunglasses and I cannot find my regular glasses right now. I'm gonna blame one of the kids. I'm sure they did it, although it is possible I left them in the car. The first thing that I look at in any lease, the term. How long the lease is good for. A lease is like a relationship between two people. Shorter term means shorter commitment, but it also means less security. Think about that. If you have a 1-year lease, it's good. You're not going to be on the hook for 20 years. But what happens after that 1 year? If your landlord doesn't want to rent you the same premises, you might be out of a shop. That being said, if you're signing a 20-year lease and you don't know where you're going to be in 2 years, it's not the best idea because you are signing on for an extended period of time, committing to one location for 20 years. Shorter the term, lesser the commitment, but lesser the security. Longer term, longer commitment, but greater commitment. What? The longer the term, the more security, but the greater the commitment. And then you have something like marriage, which is till death do you part. The most critical, all-encompassing commitment anyone can make to another person. So while the term is one of the most important things, the rent is also the other most important thing. Above and beyond the dollar figure per month, rent can be sometimes what they call base rent, which is a certain fixed amount, plus what they call additional rent. Additional rent being your share of the overall expenses of the building. Because typically you have more than one tenant in a building, unless it's a single tenant building. Take, for example, a shopping center. If you are in a shopping center, you're going to have your base rent, but then the landlord is typically going to divide up among all the tenants all of the expenses relating to the shopping center, so you will be paying an additional rent, typically based on the size of the premises that you are renting. It's important to know what those amounts are roughly in advance. They can be somewhat onerous sometimes if you have to pay a percentage of property tax, HVAC, maintenance, electricity, hydro, all the things that a landlord is going to say, I don't want to pay for this for the overall building, I'm going to divvy it up among all my tenants. The easy way to have a rough idea as to what they're going to cost is looking at previous year's expenses and then knowing what your percentage is going to be going forward of those expenses historically. Sometimes you will see a landlord asking for a percentage of rent. No base rent, no additional rent, just a percentage of sales. This, like a relationship, is good also because you're both taking a risk. The more money you make, the more rent your landlord gets. Two things that are risky about this. If you make a load of money, you're going to be paying a load of rent. But typically when people are making money, nobody really cares. The thing I don't like about it is that it gives your landlord access to your records. Your landlord gets to see how much money you have coming in. Term, rent. The other thing I necessarily look at, and sometimes before anything else, are they asking for a personal guarantee, surety, depending on your jurisdiction? Are they asking someone to guarantee the amounts owing or that will become owing under the lease? So I scroll right to the end to see if there's a guarantor, a surety, an intervener. It has a number of names. Is someone being asked to personally guarantee the obligations of the tenant under the lease? Because oftentimes you will have a company signing the lease, which may or may not have assets. So the landlord's going to say, well, if the company, which is a shell company or a newly incorporated company, is unable to pay me, I want to make sure that there is a physical person or security at the end who's going to pay me. So I make someone else sign to guarantee the obligations of the tenant under the lease. To the extent that it's possible, I try and make sure that my clients never sign on as personal guarantees. Oftentimes with big tenants, it's an obligation you can't get out of. They're going to say, no security, no lease, because I'm not taking a chance on an empty shell company that has no performance or track record. Term, rent, personal guarantee, and we'll go on and I will impart my observations as I walk through this lease. Use of the leased premises. What is the premises going to be used for? Landlords often like to define the use of the premise so that the tenant can't start off as, let's just say, a clothing store and then turn it into a nightclub. From the tenant's perspective, you want to make sure that the description of the use is not overly restrictive, so that it doesn't say something like, the premises shall only be used for a hot dog stand, seating 12 people, serving lunch from 12 to 2, because then you can't do anything else with it. The broader the better from the tenant's perspective, but the broader, the more risky for the landlord, which is why they're typically going to want to restrict its use in general terms. Clothing store, a retail store, a liquor store, premises serving food without alcohol, premises serving food with alcohol, because those are two very different businesses. So just review the description of the use of the premises and make sure that it is not overly restrictive for the tenant, because that can be a problem if their business morphs into something else. I have had clients open up a retail shop and then want to insert a cafe into it. Had the description of the premises not permitted for such an expansion, the landlord could have said, no, you're not serving coffee in here. Now, the use of the premises, as described in the lease, goes hand in hand with something else, which is very important. Any exclusivity in a lease, if any other tenant within the building has exclusivity, it is going to be mentioned, or it ought to be mentioned, in the lease that the current tenant is about to sign, because they need to know what they can and cannot do based on other tenants' exclusivity. And if your tenant is going to want to sign a lease and wants to have exclusivity, you have to make sure that it is not only in your lease, but that it is included in the other tenants' leases, so that nobody comes in at a later date and starts opening a business that competes directly with your business. I actually had an amazingly intense file where this very issue came to the fore because one tenant thought he had exclusivity. The landlord said, no, you don't have exclusivity, and I'm allowing someone else to open up shop who directly competes with you and may very well put you out of business just because of their respective buying power. Leasehold improvements. It has different terms in different jurisdictions. It basically means changes that the tenant makes to the premises to fit their needs. Oftentimes, the leasehold improvements will become part of the premises, and when the tenant leaves, they're going to become the property of the landlord. So bear that in mind. I like to sensitize my clients. If you're going to put in $1 million worth of leasehold improvements, be prepared to not be able to take them back with you when you leave. The flip side of that is sometimes the landlord's going to say, I don't care what you do to the premises, put in $10 million of leasehold improvements. When you leave, you're taking them out with you. I want the premises back in the same condition it was when I rented it to you. That can be a very costly proposition for the tenant as well, who, at the end of the term, may have to bring the premises back to the original condition. Things to think about. Signage is another sort of obvious one, but some landlords say that a tenant can't just put up whatever signs they want. They have to get the landlord's permission, both for signage actually and for any major changes to the premises or any construction to the premises. Also, to consider the municipal restrictions on certain signs. Some municipalities say that you can't have signs protruding out from the building too far. You can't have neon lights. That is all jurisdiction fact specific to be determined on a case-by-case basis. Insurance. Typically all leases are going to require the tenant to have tenant insurance. The thing to look at is how much insurance is the landlord requiring the tenant to have. This will vary depending on the business. I've never seen anything less than $1 million in liability insurance. I've seen up to $5, sometimes more $1 million. This is something to bear in mind in terms of the costs for the tenant, because a $5 million liability insurance isn't free. Related to the insurance, I have seen leases where the landlord insists or makes it a requirement to be named as a co-insured on the tenant's insurance policy, so that if there is an event, any monies that the insurance company pays out are going to be paid out jointly to the landlord and the tenant. Continuous operation and hours of operation. Not critical, but important nonetheless to bear in mind. What are the business hours of the premises of the shopping center? What does the continuous operation mean? Do you have to be open from 9 to 5 days a week? Do you have to be open from 8 to 8, 7 days a week? Some landlords will say you have to stay open during certain hours necessarily because they want to maintain foot traffic through the building. If it's a shopping center, they don't want to see closed up shops at 10 in the morning on a Monday. Assignment of a lease. Pretty much all leases are going to say that you can't assign it, which means transfer it to a third party without the authorization of the landlord. Subletting, you want to bear that in mind as well, because sometimes the landlord is going to say you can't sublet without the landlord's okay. And sometimes they're going to say even if the landlord gives you the okay to sublet, you as tenant are still primarily on the hook towards the landlord, meaning the landlord is not going to have to worry about fighting with your subtenant for rent that is owing to the landlord. They're going to come to you for it, and if you have a problem with your subtenant, that's your problem. This is the most important one to bear in mind when you sensitize your client to what happens if I don't pay my rent in time. Extrajudicial termination of a lease. I can only comment from Quebec jurisdiction. I'm fairly certain it is a permissible clause in all jurisdictions, at least in terms of commercial leases. Extrajudicial termination of a lease means the landlord says, I'm canceling your lease. I don't have to go to court to have a judge say that you're terminated and I'm kicking you out. I consider the lease terminated. I'm going to come and change the locks, kick you out, move your stuff onto the street. So just make sure of the terms of the extrajudicial termination, the notice that's required, the delays. Very important to go over that so your client doesn't say, I didn't realize that if I was 5 days late on rent, the landlord can terminate my lease, kick me out, seize all my assets. Getting to the seizing of the assets. Hypothek. This word may be different in other jurisdictions. Basically, it means that the landlord has secured your assets to satisfy the obligations under the lease. Not a personal guarantee because it's not based on a person, not a surety or an intervener because it's not a third party guaranteeing it. The landlord in the lease requires the tenant to either maintain a certain amount of stock on the premises of a certain value, let's say $50,000, so that if the tenant is in default of say $50,000, the landlord knows that in theory there are enough assets in the premises to repay the landlord for what's owing to him. It's called a hypothèque in Quebec. Important to bear in mind because a lot of leases are going to say that the landlord has a hypothèque on what we call the universality of the assets of the tenant, meaning receivables, assets, movable property within the premises, so that if the tenant is in default and the landlord comes in and extrajudicially terminates the lease, changes the locks, kicks out the tenant, he can then seize the movable assets to dispose of them in order to repay himself the sums that are owing by the tenant. That's pretty much the general aspects of a lease. I've gotten to the end of this one. If there's a broker involved, typically it should be stated in the lease because there may be a brokerage commission to pay and you don't want to have to fight over who has to pay it, how much is owed, and to whom it has to be paid. Yes. Dispute clauses. Look out for the dispute clauses. In Quebec, a lot of leases are going to contain arbitration clauses, which means that you have to go to arbitration to the exclusion of the courts. I don't know what this is in other jurisdictions. I suspect it's similar, but you want to know how disputes are going to be resolved. Do you have recourse to the courts or do you have an obligation to go to arbitration? Arbitration, at least in Quebec, has benefits, but it also has pitfalls because it is fast, it's efficient, it's confidential typically, but it's also incredibly expensive because you have to pay not only the lawyers, the arbitrators themselves, who are typically retired judges or lawyers, and they oftentimes charge more per hour than the lawyers involved. Faster, more expensive, confidential, until, we're going to get into some details, but until you have to have the arbitral award homologated by court, and in which case it becomes public typically. But that is getting into details that I don't want to get into. So that's it. Reviewing a commercial lease. Fun, wonderful, exciting. Oftentimes it's not a question of telling the parties what to do. It's just a question of making sure that your client understands what he or she or it, if it's a company, is doing, because leases can be long. They are written in a jargon that only lawyers can understand sometimes, and sometimes not even lawyers. I am personally a fan of shorter versus longer leases, simplified versus complex language, but I typically don't draft the leases. I get someone sending me in this case, 37-page lease with 100 provisions. Unnecessarily complicated, unnecessarily wordy, unnecessarily convoluted at times. But if people made it simple, nobody would need lawyers. And what a world that would be. Peace out.